So I request all the participants to kindly join on time. So this was our organizing committee, and in the second session we have Professor Christo Ananth. Christo Ananth, sir, thank you so much for joining in. Again, for the instructions, everyone, please log in through your registered email ID only, and please ensure 80% minimum attendance for this event. So, in this research essential, the first session kick started off in full fledged, where we had around 1,000 plus participants from national as well as international places. So, in looking forward to this session.
Thank you, Professor, for your brief introduction. Actually, initially I got in touch with
Thank you, sir.
Dr. Shruti with the Kudum app. I take this
Yes.
opportunity that now all people please join Kudum app, because very recently I got in touch with this app, and definitely it is opening up many gates. Like everybody
Right.
was able to share some useful information, especially in this pandemic period when everybody is caught maybe in the universities or maybe at their homes. This was a powerful platform. Like every time I get to know about new information, and that's the reason I got in touch
Right.
with Dr. Shruti, and of course with the Chandigarh University people as well. So thank you, Professor, once again. Yes.
Pleasure, sir.
Yeah, thank you. So once again, I'm thankful to the management for giving me this golden opportunity to share something about the need of the hour, which is patents. Of course, everybody knows about patent. I'm not here to introduce something, but I'm just here to brush some concepts with regards to process filing of the patents as well, and how it will be an asset, a lifelong asset to your career as well. So I'm not going to waste much of my time in my introduction. So yes, I'm going to share my screen.
Sure, sir.
So I hope my screen is visible to you.
Yes, sir, it is.
Okay, good. So I hope my audio, video, and my screen is visible. I'm clear enough.
Yes, sir.
Okay,
Yes, sir.
right. So this is all about today's session. We'll discuss much more about the process and impact of the modern day pattern. I regard this as a modern day pattern because back in 2019, 2020, we started to hear a new word called pattern. Before that, we were used to conference articles, research publications. Then came books. Everybody started to author books. Then came book chapters. Then came thesis. Then came funded projects. Then we now many switched on to patents. Like by 2019, now Indian people started to look out for patent. Initially, everybody, patent means a patent, which means anything, a design patent or maybe a utility patent is considered as a patent. And nowadays, like people are trying to understand the difference or the meaning behind what is a patent, what is a design patent, what is a standard patent, what is an innovation patent, what is an utility patent, how we can file it, how we can go for the Indian means, how we can go for the international means, what is the short term process, can we approach the patent attorney. So this is all about modern day patents. I think with this webinar or maybe the faculty development program, everybody would get a deep insight onto patents. So this is especially for you, my dear students and young researchers. Of course, I regard myself as a student as well. So this is for you, my dear colleagues and young researchers. This is Dr. Christo Ananth for you, and you can reach me at dr.christoananth@gmail.com. So before beginning the session, let us all take 1 minute prayer. Amidst this pandemic period, we should thank God for keeping us safe and healthy these days. As for me, academically and professionally, I thank God for giving me this golden opportunity to deliver this useful session, to share my knowledge among my fellow national, international participants, students, and young researchers. So these are the professionals I would like to thank to the patrons of this university: Satnam Singh Sandhu, Chancellor, Chandigarh University; Professor Dr. R.S. Bawa, Pro Chancellor, Chandigarh University; Professor Dr. N.T. Rao, Vice Chancellor, Chandigarh University; Professor Dr. Satbir Singh Segal, Pro Vice Chancellor, Chandigarh University. And the advisors and conveners and the coordinators of this program, Professor Dr. B. Priestley Shan, the Dean Academic Affairs, Chandigarh University, Professor Dr. Sanjeet Singh, Dean Research, Chandigarh University, Professor Dr. Samiruddin Khan, who has been the Executive Director of CSE Department, Professor Dr. Sandeep Singh Kang, Professor and Head CSE Department, Dr. Shruti Agarwal, Associate Professor CSE Department, who has been the coordinator of this event, Engineer Jasneet Kaur, Assistant Professor CSE Department, Engineer Lisha Yugal, Assistant Professor CSE Department, and Dr. Raman Chadha, Assistant Professor
Professor
CSE
in,
Department.
yeah, he's professor in CS department.
Yeah. So I'm thankful to all the coordinators, all the advisors and conveners. Without this presence and your organization and support, this event would not have been possible. And I'm happy that this event has crossed 1,000 plus registrations, and the count is still increasing. And thanks to all the active participants in this Zoom platform. So once again, thank you, my dear colleagues and friends. So this is what we are going to discuss at a glance. We are going to get in touch about a short introduction to pattern. And this has been a common mistake that everybody has been doing. Don't go public very soon. Okay, remember these words. And benefits of patents, and deciding if a patent is the right choice. How you can engage an attorney, a patent attorney, who can actually apply for a patent. If you decide not to patent, that also is possible. Then we'll discuss something about the different types of patents. We discuss about the standard patent, innovation patent, how you should search patents, patent information, and about the various cutting edge technological advancements that is taking place and how you can transform it into a patent, and significance of infringement search, using competitive product information, and then finally it's a commercial financial basis of how you can think about patent as an investment decision. Okay, and finally, patent can be considered as a lifelong asset. Of course, at regular intervals, I'll be entertaining you with some short videos which can explain the knowledge in topics. Right. So here are we in the short introduction to patents. So I can very well confidently say a patent, if you can say, okay, let me term the word called patent. Now, how many of you have idea about patent? Or what I can say, how many patents do you have to your credit? I want to get a statistics, at least some who can
Write down
participate.
your numbers in the chat box, please.
I just want to know how many patents do you have to your credit. It can be 1, it can be 2, it can be 3, it can be 0 even. Everybody is new in this field of patents. How many patents do you have to your credit? Because I really have a truth to discuss about this question. How many patents do you have to your credit?
Most of the participants
Most
do
of them,
not have any
okay,
patent.
most of them have 0. I'm happy that Rita Rani has quoted 2. That's good. Abhinav Sharma has quoted 2.
Some have 1 and 2.
Shanki Goyal has quoted 3. That's good. Okay, right. Now my question to those 1, 2, and 3. Okay, those participants who have commented 1, 2, and 3. Again, I'm asking you, how many patents do you have with patent number? I'm asking those participants who just answered 1, 2, and 3. How many patents you have your patent number? Okay. Okay, Suganya has quoted 4. Purnima again 4. Now, my simple question to you: how many patents you have your patent number, or you can say it is the complete meaning? Can I get at least one participant who can say I have a granted patent, or maybe I can have a patent number? Anybody? At least you can unmute yourself. Even I can answer me. I have one patent number. I have two patent numbers. Whether it can be national, it can be international, whatsoever. Sabarish has quoted one. Suganya has quoted one. I believe the number you are telling is the granted, no, the patent number, right? Okay, so this was a question that has to be asked to every other faculty or maybe every other researcher in this field. Okay, so getting a patent, showing that in Facebook. Okay, I have one patent, I have two patents, I have three patents. Now the question lies is whether you have got your patent really granted. Only if it is granted, you will have your patent number. Okay, so it doesn't mean that you have sent a paper for publication. It doesn't mean that your paper is published. So same case happens with patent as well. Many try to try to publish it fast track within 5 days, within 7 days. Okay, and showcase to everybody. Okay, I have a patent. Okay, but it doesn't add any sense. It doesn't add any meaning to a patent. Okay. So now I'm bringing you the real definition of a patent. A patent is a right that is granted for any device or maybe a substance or maybe a method. It can be for a new process, it can be for a new device even, and that's something useful to the mankind, something that's useful for the society. So you can say a patent is a legally enforced right to commercially exploit whatever you are trying to bring out a new life for a patent. It should be unique, it should be inventive, it should not be others copy paste work, and it should be innovative enough that whenever it is being granted, it can invite some new claims, but still it is unique. It is something different from the other ideas. And I can very well confidently say a patent is a legally enforced right for a device, substance, method, or process. Okay, so whenever it is being granted, you get the commercial rights for your invention. So patent is not about gaining money, but the thing is that you gain rightful right to your invention. Okay, so it will determine generally the duration of your protection as well. So for example, if you are getting a patent, okay, maybe let us take in the case it is granted, you don't own it for a lifetime. Okay, but you own it for 8 years, you own it for 12 years, 15 years, or maybe it up to 20 years, and after that you should renew it. And when you are going to renewal, it is subjected to new claims, you should tackle it. Okay, because you cannot say new ideas don't pop up. New ideas are going to pop up at any point of time, and it is subjected to claims. So you can say normally the easiest way is to go for an innovation patent. Okay, it can last up to 8 years, but innovation patent, like slowly, like even in developed countries like Australia are trying to phase it out. Okay, and the standard patent may last up to 20 years. The examination process is rigorous enough. And if you take in the case of a pharmaceutical field, it can last up to maybe 25 years. If you take in the case of IP Australia, so when you take in the case of the easiest way to go for a patent for young researchers like us, you should go for a Australian innovation patent. Okay, so all Australian patent applications should be filed with the IP Australia. You can search for IP Australia in the Google, and you can generally assess your application, make sure it meets all the legislative requirements as well. And for this case, for a young researcher like us, you can get some professional assistance. Okay, like applying for a patent, what are the ideas that you have put forward, is it really worth to be patentable, that you can discuss that with the attorney. So if you're maybe a SME, small and medium scale enterprise, then you can access the SME case management service. If you do not have a legal representation, or if you are a independent researcher, then you can go for a SME. And this service, definitely it will be connecting to the IP Australia subject matter expert, who is your single point of contact. Definitely they will help you how to go for the applying of patent, what are the examination process that is involved, and it will include like general information and search questions as well. So normally, like within the IP Australia, you will have the application guide as well. So you can find out how to file a patent, how to apply a patent. What are the ideas you have? Okay, so what is the idea that can be patentable? That you can discuss that. Okay, if you can do it, you can do it, or you discuss with the patent attorney. This is the golden words of today's session. Don't go public too soon. Okay, don't get panic. Don't march forward very soon. Okay, be aware that if you try to demonstrate, if you try to sell, if you go for an invention in public before filing an application, definitely you will not get a patent. Okay, but discuss with your colleagues, discuss with your employees, discuss with your business partners. Okay, have them sign a confidentiality agreement, then go out for the public. Okay, now it's all about displaying something about what you have. Okay, no, the thing is that you should wait, you should observe what the things are going around, and then you go for getting it public, at the need of the heart. There are several benefits of patent. I can say with the case of even with the Australian patent system as well, we have like new inventions coming up, and there are several millions of dollars in earnings. But I would rather suggest, don't think about the money that you are going to earn. Think about the right you own with respect to the IPR. So a patent will give you the right to stop others from manufacturing, using, or selling your invention, maybe in the case for the Australia, without your permission. And it is going to license someone else to manufacture your invention on the agreed terms. Or maybe you can even, if you own the right, you can even take a legal action against people who are trying to use the invention. Normally, this is the part that everybody will try to think about. Okay, I own a patent, now I can take right on each and everybody. Okay, yes, it is okay, but be careful enough. Okay, when you take an action, you should know about the consequences as well. Even you have the power to transfer the technology to for example, in the case of the Australian patent, you transfer this technology to Australia even. Okay, so which are giving the trading partners the incentive to provide similar rights and protect our exports in the markets overseas. So you should think about 360-degree overall in order when you are going for a patent to go public very soon.
Dr. Ananth.
Yes.
One of the participants needs to check their previous slide.
This one.
Barun Mandal sir, please share. Yes, I believe this one.
Okay.
Yep.
Yes, sir.
Barun Mandal sir, any questions? I guess you may continue, sir. Sorry to interrupt. The participants were wishing to see the previous slide. They are taking keen interest in the same.
Okay. Don't go public very soon. That's actually the golden words of today's session. Okay. Once again, I'm telling you that don't go public very soon. Okay.
Thank you, sir. You may continue.
Okay. So you can decide actually if a patent is the right choice. And for example, if you have developed a new device, or maybe a substance, or maybe a method, or maybe a process, you should decide it is a part of the business strategy even. And you can say a patent can be a right choice if it has the potential for commercial returns, which generally outweighs the time, outweighs your effort and money even to maintain a patent. Okay, and you can say this the patent generally it lessens the risks of IP theft in the markets that you are interested in. and generally you can manage all the IP resources that you are going through. And whenever you go for any search, okay, maybe a patent search, innovation patent search, standard patent search, or maybe any patent search that you are going through, maybe you can get to know, okay, that you have developed a unique technology which is completely different from others. Okay, and still patent can be a right choice because you own that invention and you have decided to keep it as a secret. So if you are going to decide finally that the patent is the right choice, and then you go for making it public. Also, with the case of applying for a appropriate form of protection, generally we will have like necessary documentation for your patent application as well. So for this case, for even in the case of the innovation patent, you can go for a provisional application. Okay, so provisional application, generally it's a safe way about how you try to, or when you try to apply for a patent. Okay, so provisional applications generally very cheap even, and give you the earliest possible priority date. So with the priority date, maybe you can make sure that you would be the first person to file a new invention with the team as well. And generally it might take up to 12 months to consider your options before deciding to proceed with the patent application as well. So whenever it comes to discussing things with the the provisional application, even go for a provisional application which generally it's going to offer a cost lessened service, but still you can get the priority date even, and you can decide things accordingly. And if you are thinking about establishing or maybe expanding your business overseas as well, you can go for PCT application, patent cooperation treaty application as well, for your invention. So we will get a quick indication about whether your invention can be patented or not. Okay, because I should tell you some interesting things about the patent as well. Back in 2019, when I started to learn about patents, okay, I had some 5-6 ideas with the with my students, with my researchers. I was able to think about, okay, making it as a patent, making it as a product. Okay, but when I discussed this with an patent attorney, only then I started to think about I get to know about the real scenarios, because some patents was not worth to be patented, was not worth to be publicized. Okay, so that's the reason I decided to think about all the different possibilities. Okay, and then I came to a conclusion, okay, these are the ideas I should patent it. Okay, normally patent attorney would recommend to use hardware projects as well, which use embedded systems, or maybe VLSI technologies. Even with the case of the hardware tools of image processing as well, we can still go for patenting these ideas, but make sure it is patentable or not. And that's the reason you should get the support of a patent attorney. For the first time applicants engaging an attorney, generally it would increase the chance of success. And even the IP Australia will have a toolkit, a step by step guide on how, why, what, and when to engage your patent attorney. So we will have like several basics, even how to engage an attorney for your project. Definitely, it might go step by step, but rather I would suggest IP Australia, with the case of Australian innovation patent, is the easiest way, where our young researchers, where our young people would get themselves enriched with some granted patents. So who can apply for a patent? Okay, so a patent generally can be owned by a sole inventor, or maybe a group of inventors, maybe 5 or maybe 10 even. Even in China, we have like 10 inventors, 14 inventors. Okay, now they have come up with several innovative ideas even. And a patent can be owned by the person who has legally obtained the rights to the invention from the inventors. Maybe after getting the rights, he can do that. Similar to taking a movie, okay, directing a movie. Maybe he has given the rights to somebody, they can own it. Okay, a company, organization, or maybe other employer of someone who made the invention in the course of their normal duties, Generally, for Australian patent, generally the address, this is a key point in the Australian patent, the address, the mailing address should be in Australia or should be in New Zealand. So make sure that you don't provide a national address. Even if you provide any other address, it will be rejected. Okay. And your address for correspondence can be anywhere in the world even, but the address for legal service should be in Australia or maybe in New Zealand. And a firm or partnership is unable to obtain a patent, but still the patents in the firm can go for a joint collaboration in their own names. So that's the way how and who can apply for a patent. And if you decide not to patent, okay, so this is also, you should have a note about it. You may decide that patenting is not the best option, maybe for some cases, because as I told you, I came up with 5 ideas. I discussed with the patent attorney, and I was able to get only 2 of them okay. Okay, remaining 3 are not okay, which means I decide not to patent these 3 ideas. Okay, so I prefer to keep my invention as a trade secret. Okay, when I try to make this decision, then I should assess the risk of someone discovering my invention. Okay, or maybe my invention is a product by reverse engineering. So I should think about all the possibilities. Okay, it is similar to directing a movie. Okay, whenever you come with a new idea, you are born to criticism. Okay, whenever you try to index your research article in ResearchGate, there are powerful researchers in that field and they will try to comment on that. So be open for criticism. Okay, but the criticism, you take it as a constructive criticism. Okay, don't think okay everybody is trying to criticize, okay, my idea is not that good. Don't think about it that way. Everybody are new, everybody are young. Okay, I was also new those days. As days passed by, okay, we started doing something new. Okay, and we also need to consider the consequences of someone else independently developing the same invention. Okay. So remember these golden words: don't go public very soon. Okay, while no one would have a commercial monopoly on your invention, your competitors would be free to use it for their own benefit. So, uh, just keep it as a trade secret, and when time comes, publicize it at the need of the hour. And there are several types of patents. I think at least after this webinar or maybe after this faculty development program, everybody will understand the difference between an innovation patent, standard patent, utility patent, and so on. Okay, so you should know what are the standard patents, what is a innovation patent. Even Australian, with the case, innovation patent is gaining boom. Okay, but still, the Australian innovation patent is phased out. Okay, but still you can go for a standard patent application as well. So what you can do, you can consider filing a provisional application or seeking an international protection. And there are differences in the cost of the patents. Okay, the length of the protection they offer, which means the validity of the patent, the time they take to process, to examine. It might go up to 1 examination, 2 examination, 3 examination, and so on. And the type of invention they seek to cover as well. So if you are maybe SMEs, then you can go for and if you do not have a legal representation, you can go for these processes as well. So next we'll go for a standard patent even. So standard patent definitely is the best and the highest choice even. It is going to offer long-term protection, and generally you will have control over your invention up to like 20 years. Similarly, as I told you earlier, with the case of pharmaceutical sciences, even it can go up to 25 years. Okay, but the thing is that it should be new. The steps should be new. Okay, the methods should be new. Of course, the methods, the combination methods should be new even. And invention, you should understand that it's not the obvious thing to do for someone with a knowledge and experience in the technological field, but your invention should be in some way, okay, maybe to 0.5% it should be different from the existing technology that everybody is trying to use. Okay, so like whenever it has a strong background knowledge as well, but still the steps should be inventive and should be productive enough for the society and for the mankind in which we live. So it should be, whatever the application that you are trying to review with the team, they will try to review it, and they try to make sure that it might meet the requirements. Generally, for an examination, it might take up to 6 months to 1 year for examination of standard pattern. This was the case of innovation pattern. As I told you, like back in 2019, September, October, or November, I started to discuss about this innovation patterns of Australia. And generally, very recently, like in the website, they said, this was the information they gave in the website. Existing innovation patterns that were filed on or before 25th August 2021 will continue in force until the expiry of 8 years, but still after that it is not considered. But they keep on changing the dates, but I rather recommend, okay, if you want to go for a hit and miss, then you can go for this Australian innovation pattern, else you go for an Australian standard pattern even. That's a good choice where you can offer protection for invention, for new innovations as well. And definitely they have their own rigorous process of screening and examination as well, and if it doesn't meet, they will tell that openly, directly they will tell that, okay. But still, if it is okay, then they will giving you some claims, they will ask some queries, it will go for 1 examination, 2 examination, and so on, okay. So here the innovation pattern has an innovative step rather than an inventive step. So you can see the difference. Innovation pattern has an innovative step rather than an inventive step. Okay. Here an innovative step is going to exist when an invention is different from what is known before. Okay. So it should have a substantial background information, and it should support that your process is innovative even. So we will therefore definitely try to come up with an idea which has a strong background information and is different from the existing technologies. So this innovation pattern is actually legally enforceable if it has been examined by the IP Australia and found to meet the requirements of the Patent Act of 1990, and a patentee will not be required to pay for the examination until it is being requested. Okay. For the Australian innovation pattern, they have a different process. Like maybe they go for a granting soon, and after that they go for the examination. Okay, so that's the way they do it. But for other patterns as well, they examine it first and then they grant it. Okay, so this is something different with the case of the Australian pattern as well. Okay. So now comes the most important part, which is nothing but searching patterns. So before you come up, you have your own idea, but before filing it, or maybe before applying for a patent, you should conduct a comprehensive search for the patent information. Okay, so definitely you can avoid spending time, avoid spending money even for the protection, because naturally if you have an idea which somebody already has and already has been published or granted, then definitely immediately for filing fees, that is going to be in vain for you. So before going all this one, search for it. Okay, because before publishing your research article in any reputed journals, Scopus or maybe SCA or maybe Web of Science, we naturally type the title, we naturally type the abstract. Okay, so that's the way you should search for it. So searching for patent information, definitely it can be complicated, time consuming and costly as well, but still you can get the assistance, a special advice from the IP professional even to conduct the search. And definitely if you are a small scale, small and medium scale enterprise even, you can get access to the premium SME case management service. So that's the way you get to know about the advanced search options. So before introducing a new product to the market, definitely you should ask in business way, okay, business point of view, okay, can I protect my invention with a patent, or does my invention infringe someone else's patent? So these are the questions you should ask. Once again I repeat, can I protect my invention with a patent, or does my invention infringe someone else's patent. Okay, so if you are going to get answer to these questions, definitely you are going to determine who owns what intellectual property, and you can check whether your IP is not being infringed. Obtain product information on your competitors for research purposes. I would rather relate this scenario with a reputed SCA journal publication and your patent, because both the cases you are bringing something new. Okay, so normally people tend to make mistakes like this, like they try to publish the paper in SCA, okay, and after that they go for invention. Now this becomes meaningless, because patent is something like a product which is innovative, which is inventive enough to the other existing technologies even. So before, at least maybe like 1 month before the publication, 15 days before the publication, go for filing a patent. So which means your publication will have no effect, and similarly your patent would also definitely be granted, because when they try to search for this particular idea, they will see that you have a SCI publication, and definitely that's a added advantage to the people, because both the ways it's going to benefit you. So which means you are going to publish your idea in a reputed SCI ISI Web of Science Index journal. Similarly, you are going to patent an idea into a product. So this is prior art. So it's information on the inventions that have been already been publicly disclosed. So you can say a prior art search will definitely give you an idea about what technology actually exists in the real-time scenario, and definitely you can make an informed decision whether your invention is unique or not, whether you can hold the right of gaining the patent protection. Okay. So that's the reason you can search for it maybe in the patent cooperation treaty database. You can go for several searches. Maybe you can get access to the Australian patent database as well as you can get access to the overseas patent databases as well. Similarly, in Google Scholar is a powerful platform. Who knows that maybe the patents, publications, conference articles, research articles, magazine articles, newspaper articles, patent. Do you know that you have a word called patent whenever you are trying to include a new article in your Google Scholar profile, like add a new article, add a new conference article, add a new other article, add a new dissertation or maybe project, and then add a new patent as well. Okay, you also have a court case even. Okay, so patent also comes here, and you can search for the patents in the Google Scholar. Several existing products, proprietary databases, even you can search through. Of course, in this new technological advancements, you have the internet. You can search for Google about whatever product you are searching for. So here the patent information, as I told you, you can go for a Google patent search where you have a patent database. Definitely it's a good place to start your search. If you are limited with some resources as well, and generally you can find a similar invention, and you can avoid the time and cost of a wider search. So the databases will be having like several patents given, and generally if you compare the Australian patent with other patents, it will reflect only a small percentage of the world patenting activity. Normally, like many will go for US patent, many will go for Korean patent. So that's the way it goes. Making sure you don't infringe someone else. So when introducing a new product, you need to make sure it does not infringe someone else's patent. So searching the database would be the right choice. And if you are making, maybe let us take an example, a wooden coat hanger or maybe plastic plates even, generally there is a chance that you might copy somebody else's patent. Okay, so since wooden coat hangers and plastic plates have been made a market maybe like 20 years back, okay, so everybody knows that it is a existing technology. So you should try some new ways, like what we saw in the video about coat is the same, but how you make the coat, how innovative the coat can be, really matters. So giving the gift of the cutting edge technology advancements every microsecond, Generally, you should conduct a patent infringement search and technology. My infringe a patent that is not yet expired even. So you should ask these questions: is the product made up of a number of components, or if that is in the case, should you conduct a search for some of them or all of them? Okay. So maybe your pattern would maybe it would be a product would be having like number of components. So for each of the components, should you need to infringe themselves, or maybe all of them, or maybe some of them you should infringe? That really matters. And how will you interpret the claims of any of the patents? You try to determine whether you may be infringing them. And reading and understanding the claims of a patent, definitely it is going to be a challenge. So it is all about the examination process that you are trying to implement. So you can access the full range of patent as well, and you can browse through the categories, even like for example, a software program for controlling the X-ray machines can be classified under data processing or maybe image processing, okay, or maybe medical equipment as well. Okay. Also, you have to determine that's a outstanding patent application on your particular product that you have been trying to develop. Okay. So patent applications may have been filed but not yet have been published, but still they are unsearchable. Okay, so you should think about that area also. It can be filed but it is not yet published, but now you have come up with an idea. Okay, so unless somebody gets a patent granted, only then it comes into the database and it pops out to everybody. So when a patent is granted on that application, your product may infringe it. So that's the case. So you should be slow and steady as well, but still keep intact with all the technological advancements. And there is significance of the infringement search. So that's the way it goes with the image as well. So patent searching, once again, it's a complicated task as well. So searching will not always guarantee that your patent does not infringe somebody else's work. That's what I told you, because sometimes it would have been filed, but it would not have been published. But now you have come up with a similar idea. So that's the case. The thing is that you should be open to criticism. You should be open to claims. You should be open to examination every now and then. I gave my real time situation as an example for you. So just by December 2021 or January 2022, our patent is going to get granted. Now comes 3 new claims. Now we have to face the examination thing, and then we have to get it bypassed. Okay. So if you then generally you should have a better infringement search as well. You should have a detailed technical information about your product, where you can make, or maybe how you should make your product, even where you sell or intend to sell your product, when you first made it and sold your product, and whether your product is intended to be used by the third party members as well. So that also you should have a clear agreement as well. Obtaining competitive product information. So here all granted patents or maybe some pending patent applications are published even. So this is the way like everybody are trying to showcase. Okay, like okay, I have like this much patents. Okay, but really the scenario is within 1 week the patent gets published. Okay, the case of the Indian patent. So when you compare it with the overseas, the Australian as well as the foreign patent databases, generally they would include huge volumes of technical knowledge even, and generally you can still go for the searching the patent databases for all the published patents, technical details of another system, even about a particular topic, about a particular product, or maybe technology, even about the details of the technology. What are the components that are available? What are the details? What are the specifications? What are the process they came forward in order to develop the product? That we would get the competitive product information. So only after knowing this product information, you will get to know whether your patent or maybe your idea is unique enough to compete enough with the other standards. And competitive product information can be used in 2 ways, maybe to design around the patent, or maybe to get a step ahead of its competitors. So which means that you can commercialize anything which is not covered by the patents claims, which means you should understand that agreement clearly, okay, details clearly, so you can patent according to that, to the specifications which they have not mentioned, okay. So you may maybe improve on the technology patented, definitely it will be a new patent, and maybe it it might contradict somebody else, okay. So your patent may then allow you to commercialize the improvement.
Anand sir,
Yes ma'am, yes ma'am.
the audience is requesting to share the links in the chat box so that they can refer to it later with the audio as well.
Yes, sure. So maybe
Maybe post the session.
should I have to do it right now or maybe after the session, ma'am?
Maybe after the session will be comfortable.
Okay. So very recently, once again, this has been my own personal experience as well. USPTO application about the US innovation pattern. Very recently, I filed during November 2021, and the process is still going on. And unless it has been published, I will not get even the application process. Even I will not get it anywhere. Like maybe it might take 1.5 years to get it published. Okay, so this has been the longest time I have ever dealt with a pattern, because normally like Australian patterns like 5 months or 6 months. German pattern maybe like 5 months or 6 months. Similarly, the other patterns as well, they maybe Indian pattern, utility pattern, it may take up to 1 year. But the USPTO, it is taking 1.5 years for publication and 1.5 years for grant, which means up to 1.5 years for publication, my innovative idea is still under question mark. If it is okay, then it is going to be published, then it will be granted. So it's all about the examination. You can still, that's what I'm telling you, you can search the patents register to determine who owns a patent, and according to the Patent Act 1990, you are going to get protection for those who rely on the patents register. You can decide who owns a patent, okay, so which means unregistered documents are not admissible in the court proceedings except in the certain circumstances. So which means everything should go through the PPS register, National Personal Property Security Register. The PPS register can be searched. The register of the patents is not a legal security register, but the thing is that some mortgages may be recorded on a patent register. Definitely it will not be a complete record, okay, about the entire database. And if a company or firm or maybe organization owns a patent, you should search the company charge information, what are the fees that is applicable, through the Securities and Investment Commission, and to decide even whether the mortgage has been recorded on that register. So if you are able to do that, then which means that you can try to take out their idea. And determining whether the patent is valid, just because your patent has been issued, which means that it is valid lifetime, 24/7, 365 days, it is valid for lifetime. Doesn't mean in that way. So relevant prior art may not have been uncovered, which means that we have to go for several examination even after renewal even. So you may be concerned about infringing another party's patent, and however a priority art search may find that the patent can be invalidated. So I'm telling you once again that maybe a patent, if you got it granted maybe 8 years, 12 years, 20 years, and after that new claims might pop up, you have to justify, okay, your idea was brought forward maybe years ago, so that's the reason you are giving some substantial information. So you should add much more information, add much more answers to the relevant queries, and that's a way that you are making the pattern. And there are 6 myths about getting a pattern. These are interesting myths. Like everybody might have this kind of questions to our inner mind. Okay, a pattern will cost me hundreds or maybe thousands of dollars. Okay, prices might vary, but the cost of drafting and filing an initial patent application generally will cost maybe like between $3,000 to $6,000. Okay. So the cost of converting this to a full pattern, maybe standard pattern, definitely it will be roughly similar. This is also one question that everybody will try to think. There's no point in getting a patent because the big guys will just steal my idea anyway. Okay. Now, many people, not some people, many people worry that big corporations will steal their idea, and definitely they won't have enough money to fight them in the court. But if your invention is protected by a patent, they will deter many people from trying to copy it in the first place even. So don't think that big guys will try to steal your ideas. Okay. And if a big corporation infringes on your idea, having a patent will ensure you get a seat at the negotiating table. Definitely, it is going to make much more commercial settlements as well. So don't think in that way. And also, I can get a worldwide patent. There is nothing called worldwide patent. Okay, nothing is global. Okay, based on your business plan, you will need to seek patent protection in each country where you expect to sell a product. Okay, maybe the same product you can register in Australia, you can register in Korea, you can register in US. It is about how the protection that you try to get. Okay, so you cannot get a worldwide patent. And a patent attorney will steal my idea. Normally, like when you are, this is the common thing everybody will think. Okay, maybe if I'm approaching for a patent attorney will steal my idea. Maybe they will say, okay, your idea is not worth enough. It's not that way, because they should abide by the government code of conduct, okay, which requires them to be courteous, ethical, and well informed, and forbids them from acting in a deceitful or fraudulent manner. So, if somebody tries to copy, then they cannot continue in that business. Okay. So, they have their own industry code of ethics, which forbids them from acquiring IPR when there is a potential conflict of interest. So, that's where a patent attorney should act ethical. And there are some patent codes even. Okay, so once you have secured a patent, you'll have to do your own checking even so that it hasn't been infringed. But there is no such thing called patent police. Okay, so we'll need to keep an eye on the competitors' products and do occasional internet searches even so that nobody else will try to copy your idea. And there are several patent attorneys who offer the IP watching service. So don't think there is a separate department called patent police who will be monitoring everything. So you have to do your own search and you will have to protect it. Else, somebody else will try to copy. A patent will automatically make lots of money. This has been a common question that many ignorant researchers might ask this. So whenever I get a patent, so which means I get lots of money. Okay, because you are unlikely to receive business offers just because you have secured a patent. So which means you should broaden your business plan. You should commercialize your idea. Only then you can think about patent as a commercial tool, which is going to protect your idea from being stolen by others. So you can term patent as a gold, as a valuable diamond even. You should protect it. You should own the rights to it. So I can very well conclude that a patent is a commercial tool even if used rightly, and every decision you make about it, about how and when to secure a patent, should be about the intention of your invention and transforming into a money making product. Okay, and if you don't think you can make money from your idea, maybe there is some point that you have to seek a patent even, and generally you can go for taking your time and money as well. Maybe if you are thinking, okay, I have invested too much money on that patent that I'm trying to file, then which means that you should have a business plan. You should turn out into a product, and then you should make it commercially available. But the thing is that whatever you're trying to develop, you should have the agreements, even the tools what you're trying to develop, you should have a well structured layout. So once again, you can think about patent as an investment decision. You should consider it because the patent is the best use of your resources at the present point. Maybe who knows, that might take you to some other position even. There are still several ways to protect your IP, like trade secrets. That's what we saw in the video, and non-disclosure agreements even. So if you are thinking about making it as a investment, a financial decision, definitely it is your decision to make it out how you are going to commercially broaden your business plan. And going international way, maybe you can choose to publicize it as an Indian patent event, national patent event, or you can go for seeking the patent protection overseas. That's also a good thing. Once again, I'm repeatedly telling you that there is no such thing called global patent. Okay, you'll have to decide which individual countries you have to apply. They might have their own procedure. For example, if you're going for Japanese patent or maybe Korean patent, it has to be translated in their own language. So which means you should translate it accordingly, and you should bypass all the new claims. So which means you have to choose the countries what you are trying to plan to sell or maybe manufacture, and you can think about making it. So very well, I can conclude that a patent is a lifelong asset. So once you have a patent, which means that you should consider it as an asset. Maybe you can use it to manufacture, you can sell your invention, and you can generally stop others from copying it as well. You can also sell your patent to another person. You can license it for the manufacture of your invention as well. And still, with the help of a patent, generally if you are applying for any research funds in your organization, okay, maybe DST, DPD, okay, CERB, okay, any other funds, generally a patent is a added advantage because here the potential investors will want to see that their invention, whatever they are trying to come up, generally is adding new money, and it is being protected even. So you can think about patent as a lifelong asset. But the thing is that patent, if used correctly, if used properly, definitely it will be an asset, a lifelong asset, and it's a powerful tool even that you can march your way forward. So my final words for you all: don't expect others to do all the work. Instead, you tell to yourself, like, I have to initiate, I am responsible, I am the sole one, and I have to give my own advertisement or promotion. Okay, so maybe like Instagram or maybe Facebook or maybe WhatsApp or maybe Twitter. Okay, any academic profiles like Google Scholar, okay, ResearchGate, academia.edu, okay, LinkedIn, whatever academic profiles that I'm trying to showcase, I have to give my own advertisement or promotion. And never ever give up at any point in your life. Imagine this photo whenever you come up with any hurdles. Okay, never ever give up. Imagine your frog catching the neck of the crane whenever situations tighten up. Okay, whenever you are done with so many failures, academically, professionally, or maybe in your personal life even, don't ever give up at any point in your life. And thank you for your kind patience. Let's all start working. So before ending the session, let me tell you that apart from research articles, apart from journal publications, everybody would go for conference publications as well. They go for professional memberships, even national membership, international memberships even. Apart from this, you can add variety of colors to your research publications. Like many would not think about newspaper articles. Many would not think about magazine articles, publishing in magazine, publishing in newspapers. Okay, maybe get some projects being published in some reputed websites. Okay, going for research funds. Okay, whenever you are going for research fund, you should have the back support about everything. Your profile should be colorful enough that many would try to follow you. Many would have some good citations of you, and you have some good healthy academic follow as well. You have some good number of granted patents. As for me, like I have like 8 patents to my credit. 4 have been published and 4 have been granted with patent number. So that's also a thing that maybe you should have a note about this. Maybe you should keep the target. Okay, this person has got 8. Okay, I should get 15. I should get 20. Okay, do something that is going to definitely help you. Maybe you are a researcher, you are a student, you are a scientist. Okay, you are a code programmer, okay, you are a software engineer, whoever may be, but definitely research is one common field which is going to integrate us. Research is one common area that we are going to unite us, and definitely you can apply for several research funds, and for that patent is going to be a first step. Okay, make sure that it gets granted, and definitely you can go for several research funds even, and having a good reputation of QS ranking even. It's a great advantage that the government can allot fund for the university even, but for this you should have some good back support, like some good SAI publications, ISI publications, Web of Science Index publications, Scopus Index publications, patents even. Okay, so only then they will give the funds even, and go for a international collaboration even. Don't stick on to only this teaching or maybe lecturing even. Go for researchers even, and encourage or maybe even motivate your students to go for several internships, because I generally feel the only difference between our country and other countries is that we don't go for internships, we don't go for real internships, we don't go for collaborated national international projects. So if we are able to do that, then definitely we would be smart enough. Of course we are smart, but the thing is that we have to really come out of the way, and at least before the start of this session I asked you, okay, how many patents you have. Okay, you said 0, 1, 2, 3. Those numbers should be converted to 2-digit numbers or maybe 3-digit numbers after maybe in successive point of time. Okay, so thank you one and all for the opportunity given, and once again I thank the coordinators for extending a grand support, coordinating these type of activities, from 31 January till 5 September or so. It's not an easy task, especially getting in touch with the people every time, mentioning, okay, we have a WhatsApp group, every time fill in this Google form, getting all the required information, okay, and make sure that everybody is happy, everybody is safe enough, the participants are also healthy enough, they are keeping their own decorum even. That's good to watch at, and I really wish Chandigarh University to conduct some productive, useful sessions as well in the forthcoming weeks. So once again, thank you.
Thank you so much, Professor Ananth. Thank you for giving a deep insight into patents. I hope we all are well acquainted with what patent is and how to move forward with it if we do not have filed any patent yet. So we have certain questions with us. Would you like to take them up?
Yes, ma'am. Yes, ma'am.
So you're muted.
Yes, ma'am.
Sure. So, sir, there are similar two questions from Professor Rajkumar and Professor Srinivas.
Okay.
That what is the difference between Indian patents and Australian patents?
Okay, I should tell you the easiest way to, maybe if you are a young researcher, maybe if you are not much into the patent. Actually, the patent procedure in Australia and the patent procedure in India is pretty much different. In Australia, you have an innovation patent and then you have a standard patent. In India, you have design patent and then you have utility patent. In design patent, it's very easy. Like maybe within a span of like 5 months or maybe 6 months, you get your patent, get it published, but you have no such thing like granted. And similarly, you cannot have any affiliation with regards to design patent, Indian design patent. But with the case of utility patent, you can have your affiliation information, and it might take 3 years for a patent to get granted with the case of Indian patent. Okay, and a fast track you can go for 1 year, and but the filing publication procedure is pretty much same when you compare it with the 3-year process and the 1-year process. But the thing is that when you are going for examination, it might go up to 2 examination, or maybe it might go up to 3 examination. That's what I told you in the between the sessions. Like I had like 3 examinations. I was about to get it granted, but now 3 new claims have come up. Now I have to put it forward the right way to the panel members. So that happens during February 2022. So this is the case of the Indian patent, but with the case of Australian patent, the patent procedure is quite different. You should have an Australian or maybe New Zealand address with regards to the filing event, and only if you have that address you can do that. Else with the Indian address you cannot do, with the other country's address you cannot do that. And similarly for a innovation patent, it is phased out already, but still you can go for a hit and miss approach, you can do that. But if it is granted, that's fine. But the thing is that they grant it first of all and then they go for examination. But for satisfying this NBA and NAC committee, everybody will go for this Australian innovation patent, because this Australian patent will have a patent number, and that's where everybody can show it. But still, you can go for a standard patent. The examination goes on and on. I don't find much difference between Australian patent or maybe Indian patent or maybe Korean, Japanese, German patent even. But the thing is that every patent or maybe every country has their own set of regulations. Like they have to translate it according to their own language, and you have to go for examinations. If you are done with an examination, maybe in 2 or 3 countries your patent gets granted. That's not an issue. But the thing is that it should be innovative enough and it should fit their standards. If you are going to satisfy their needs, it is just like getting an idea and you are getting a degree in 2 or 3 countries. So it's all about their way of satisfaction.
Right. Yeah, thank you so much, sir. Another question from a doctorate in economics and management is that in their stream, what should they be considering writing as the name, as the patent or the IPR in the field of economics and management?
In the field of economics and IPR, management, even they can still go for IPR or maybe trademark even, copyright even. That's the best way that you can go for. But whenever it comes to patent, you should have some working model. You should have a prototype. Only then it becomes useful. I would rather suggest you can go for a trademark or maybe a copyright or maybe IPR.
Okay. Right. So similar question in the sequence is how can you differentiate between an IP, a copyright, and a trademark?
You cannot get our IPR, get it granted. It's just registering. You're just filing an idea. Okay. And similar case happens with the Indian patent also. Indian patent publication. Okay, everybody says okay, fast track. It happens within 5 days. It happens within 7 days. Maybe it might go up to 15 days, but you are just filing it. It is just for namesake. And everybody that's what I told you, for the sake of the accreditation bodies, they show it some way. Okay, it doesn't get complete meaning, but still trademark is one area that you can concentrate. IPR is one area that you can concentrate. Patent granting is one area that you can concentrate. Whenever you come with patent, the complete meaning is granting. Whenever you come with IPR or trademark, the complete meaning is filing or registering. That's the complete meaning. So you can try whatever you want to, but know about that, the upper limit about how the process will go.
Right, sir. Right. Another question by Mr. Sumit is that if they do not have the address of Australia or New Zealand, can they file a patent there?
Yeah, you can do that, but still, for the process to get completely finished, you should maybe approach a patent attorney. Maybe in that case, they will have some good links where they will be providing the address. Even I had some contradictions with this one. I was working in Gulf when I was filing my first innovation patent. So I was having some contradiction, and it was the patent attorney who rightly connected me to that address, and still it was able to make it successful. So without that address, the complete process is not possible. But maybe you would get on to maybe 2 or 3 steps, but it's not going to get it completed.
Right, sir. Right.
But this
another
happens,
question.
Yeah, I'm sorry. This happens only for the Australian patent, but other country patent, the process is different.
Okay. So it depends basically upon the region in which you are applying for the same. Right, sir. Right. Another question by Dr. Sarvana is that if a person has already the patent is in process and he's already filed it, and a similar patent work is published during that duration, so what would be the fate of the patent which is in under processing?
Yeah, that's what I've told you. Before filing a patent, I would rather suggest you to conduct a patent search first of all. Maybe make sure that your patent is filed, maybe published or not, granted or not. Only then you file it. Only then you file it. Because for filing it, you need some fee even, and then only comes the examination. Only then you have to defend it. So before going into all this stuff, go for a search. Make sure that your idea is unique enough, and make sure that your idea is patentable enough. Only then you go for filing. Okay, so before taking step number 0, think like 1,000 times, then make step number 0.
Right, sir. Right, sir. Right. There's a question by Kamar Gil sir that if we take up our IPR again, if we have withdrawn 1 year back due to some reasons, do we have to pay the fee again?
No, I didn't get this question. Sorry.
So, if they have withdrawn their IPR and they again want to resubmit it, so they have to go back to all these steps for filing. I guess yes, you have to go back to all the steps.
We have to go back to all these steps, but wherever you are showcasing this research in your company or maybe industry or organization, remember you are mentioning the affiliation of that university you are working for. So don't come up with just a trademark. Okay, that is going to happen within few seconds and we are done with it and so on. Remember, you are involved in it, your collaborators are involved in it, your university is involved in it, and who knows, you might land in a big problem if you misinterpret something. So even the university people, they might try to remove you from the institution if you file the wrong patent. Okay, so it's very a keen thing, a careful thing to watch.
Right, sir. Right. Thank you. Another question from Vidya Sagar Kumar is: can we get patent of the thesis which is not published?
Patent of, any idea which has not been published, it is okay. But the thing is that that idea should not have been published in that country's patent database. So that's the thing. If that is okay, then it is okay. Any idea can be done in that way, unless it is published, unless it is granted, anything is fine.
Right, sir. You have basically answered the question. Some questions are too obvious. The duration of the patent which you had shared, it's from 8 to 12 to 20 years. And how to obtain a worldwide patent, sir duly answered that there's nothing called worldwide patents.
It's all about the country which you are trying to apply to. So there's nothing called worldwide.
Right, sir. Another question is, sir, is it possible to extend the term of the patent protection?
Yeah, of course you can do that. It may be basically like innovation patents may range up to 8 years, and after that you have to pay the fee, and you have to renew it. Just like a driver's license, you have to renew it. But when it comes to standard patent, you are subjected to new claims, which means that you have to maybe go for an examination, and then you have to go on and on and on and on. And definitely you can.
Right, sir. Right. So, and some people are asking, can they patent their apps?
The patent is all about ideas. So if you are able to make some details or specifications out of it, and if those tools and specifications are new enough, then it can be patented.
Right. So you shared something regarding the US patent to keep it secret. So one of the participants have asked, can I obtain a patent and keep my mention secret?
Now, it all depends upon the secret that you are trying to develop, and that secret should not be a contradiction to the nation's security system. So if that is so, then you can classify it as a secret patent and you can do that as well.
Right. And some questions regarding licensing, how to get licensing from third party. Is it safe?
It all depends on the agreement. It should have a strong agreement, and definitely it should not be popping out at any point of time. So if the agreement is fine, and if the transfer of rights is legal but in this case I would rather suggest that you approach a patent attorney so that they will be doing it safely without any problem.
Right, sir. Right. So can we take one or two few more
Yeah, it's okay.
questions,
It's okay.
please?
Any more, any number of questions. It's okay.
Thank you so much, sir. So actually, the audience has been very responsive, and they are very keen on this such a intuitive topic. Everybody wants to get
Yeah.
information. Yeah. So another question is, can the decision to grant a patent be challenged?
Yeah, of course. That's what I told you. Many new claims might pop up at any point of time. You are you are subjected to constructive criticism, and it's just like defending a public viva, a public PhD viva. But the things that this PhD viva would go on and on whenever it goes for
Right.
renewal. So that's the thing. You are subjected to new claims, and definitely you can say that your idea is still the best when it comes into a matter of years. Whenever you are trying to explore new products.
Right, right. And a similar related question, obviously, is that if your patent is published, but can there be a case that it is not granted?
Yeah, sure, definitely,
Obviously, yeah.
definitely. If you are defending, if you are not defending your PhD
Right.
Viva
Yeah.
questions, you are not going to get your PhD.
I'm going to
Similar
get
thing
it.
happens with the patent even. The examination is very very important. It's forget about that publication. Get it published is not about getting 50% of work done. No, it's just about 5% work. Remaining 95% work is all about the examination process and get it granted. And also after getting it granted, you are subjected to constructive positive claims as well, and you have to answer those queries even. So better you have a patent attorney at regular intervals. I have
Right.
a patent attorney at all times because I have decided, okay, like patent is going to be a part of my academic, part of my
Right.
professional career. So I am going to regularly publish it. I'm going to regularly grant the patents. So I have been exploring Australian patents, Indian patent, very recently US patent, and now I'm going to file a German patent. So the
Oh,
process goes
wonderful.
on, design utility is going to come. I kindle some 1%. I'm sure that I kindle some 1% interest among the participants. Definitely 99% is about how you take the way forward.
Right.
Thank you, thank you.
Right. Right. Right.
And I'm sorry,
Thank you.
Professor Raman Chada, you are about to start it. I'm really sorry.
No, 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 no worries, sir.
No,
No
no.
worries.
ऐसा कुछ नहीं है.
Okay.
Thank you, sir. Thank you very much. Thanks a lot.
Thank
And I really appreciate that. Really we have learned a lot of things that
Right.
a patent gives you the right to stop others from the copy and manufacturing, selling, or importing your inventions and without your permissions. And also we can get the protection for a predetermined period, allowing you to keep competitors at bay. So it is one of the most
Yeah.
important thing is that, and we really learned a lot. Thank you very much, sir. Thank you very much. Thanks a lot.
thank you so much.
Thank you, Professor Anand. Thank you so much for connecting, and I thank all the participants for so actively being part of this session. I really thank you from the bottom of my heart. Please fill in the feedback form. It is shared in the chat box as well as in the WhatsApp groups. So we'll connect
Yes, yes.
tomorrow at 10 a.m. sharp. Please join on time from your registered email IDs. The link is same for all the sessions. Thank you so much. Thank you, Professor Anand, and thank you, my team, Dr. Chadda, Jasleen ma'am, Lija ma'am, and
Thank you
all
very
the.
much, ma'am. And it is
Thank you, ma'am.
requested to all the participants also, please join the session well in time. So tomorrow, hope some more things, new thing we need to be learned now. Thank you, ma'am. Thank you very
Thank you.
much.
Thank you, everyone. Happy learning. Thank you.